I got that.
Write it on the.
Yeah, let's. Y'all, my automatic updated telephone to daylight saving time says it's 8 o'clock. So I hope everybody yesterday enjoyed that supposedly extra hour to get something done. This may or may not be the last ag meeting. I don't know. I was going to ask Senator Black to say the prayer, but he's not here. So, Robert, would you ask a prayer for us, please?
Okay, let us pray. Our Father, we just thank you for this day you've given us and the opportunity to come together. We just thank you for each and every person here. We just lift you up to give us guidance and wisdom in all that we may do. Just be with us this morning. Be with each and every member and the decisions we make. In Christ's name we pray. Amen.
Amen.
I really want everybody to remember Rick Jaspers. His daddy died this week.
All right, is that better? All right, if we go to line 37, if you remember, the affected area was causing a little problem, so that has been tightened and given more specifically. So looking at the affected area, it now means two specific portions of the state lying in the Flint River Basin. First, those areas where groundwater use from the Florida aquifer can affect stream flows. And second, the drainage areas of Spring Creek, Itchaway, Notchaway Creek, Kitchafoonie Creek, and Muckalee Creek. Those particular tributaries are named so that anything else is not in the area, and I think this satisfies those folks that felt like the definition wasn't tight enough. Another thing that was requested, if we go to line 41, was that we define augmentation, and that definition is augmentation means addition of groundwater from one or more aquifers underlying the affected area to a surface water channel in the affected area for the purposes of maintaining stream flows, which basically is what augmentation is. So I think that pretty well cleared that up. The next change we'll find on line 173. And this change was to tighten the I guess those affected by the fact that we might have to require folks to let some water go by to protect endangered species and to ensure that the state retains control of our rights, basically. And that 173 redefines permittee as any person holding a valid permit issued pursuant to Code Section 12-5-31, where such permit provides for the withdrawal of surface water in the affected area. That, again, limits it. Now, also, we included on line 208, because even though current law, we had a lot of folks saying, well, we're giving this water to Atlanta. Current law prohibits that. However, we added nothing on line 209, nothing in this code section shall provide authority for interbasin transfer of any water. And that was to help some folks that felt like the current law was not strong enough in that. I think probably, and by the way, that's in North Georgia Water Authority law, that we could not make any interbasin transfers to them. They put that together. I think it's interesting to note that we have worked with North Georgia Water Authority. We worked with several around the state to basically structure what water conservation policies are needed for different areas, because they are different in different areas of our state. This area that we're looking at for this bill has about 38% of the entire irrigated land in the state, and it has a river flow that, except in drought conditions, is adequate to provide for all that we need. However, the last time, a couple of years ago, when we about had a drought, we almost got in trouble. This bill will help us be prepared to meet those conditions if they exist again, and we certainly hope that will not happen. But along this river, we also hoped we would never have a 500-year flood, and it did happen. And I think it's very important that we be prepared should that happen. I think the bottom line here is that if we can get this particular law enacted, that we will retain our state's rights to manage our own resources. And the farmers in this area are strongly behind this, because farmers probably are your most attentive to water conservation and soil conservation. It is their livelihood and the source of food for our state. So I would ask, Mr. Chairman, that the committee consider this substitute, and if you have others that like to speak, I'll yield the microphone.
Thank you, buddy. What we were going to do...
Okay, I'm sorry, Mr. Chairman. The
Okay.
just reminded me there was one more that that he had asked that we take out is on 199, and that did say that actually after an administrative finding that notification shall be modified, reversed, or continued by the director as he or she deems appropriate. We struck as he or she deems appropriate, meaning that it stays within the administrative law system. Well, based upon appeal or whatever by the person. Yeah. Sure. Pull up another chair. I'm going to let the director answer that one because that's within his purview, and he understands his responsibilities better than I do.
Well, thank you, committee and representative. We first of all, I think that embedded in your question is a position on ownership of water, as if groundwater is something that everyone that uses it is entitled to compensation for the use of it. I mean, in our regulated riparian system, as we've talked about a number of times before, the ownership right that a riparian landowner has is to the reasonable use of that water. And what we're talking about in this code section applies only, the restriction applies only to those regulated folks that were already regulated under the surface water withdrawals. So it is true that in this section, if we had not declared a drought and were not doing the auction, we would be taking groundwater in a very modest amount and augmenting a stream for this limited purpose. I do not see that as taking anyone's your own groundwater, private property owned groundwater in that sense. Where the well would be something that the state, when we've done this, we've had to work out and have agreements on, or do it on state land.
Compensated for the well and the water taken? And is it not true that this section does, you say a modest amount, but this section contains no limitation on the amount of water utilized for this purpose?
I do not anticipate that in this situation we would be compensating, the state would be compensating any landowner for the groundwater. No. And its limitation is limited by the practical implications here. I mean, the idea that the state, on the taxpayer dollar, would run some massive groundwater project, pumping out all over the place for nothing, and taking people's water, I mean, it's just not a credible fear. We're not going to, I mean, the reality is we're going to do this when we have to, for limited purposes, which are all defined and going to be defined by board rule, which we're going to have this debate across the street before the Board of Natural Resources, I'm sure, at length. So it's you know, the idea that we're going to pop a groundwater well in somebody's backyard without their consent and take their water at levels that would impact their reasonable use is just not founded. There are a lot of things not defined in this code, Representative. I mean, we could define, we could chase all sorts of potential things, but I think the reality is this does a fair job of addressing and confining. And look, let me just say, and I do appreciate this refining process. This has really been a good legislative process. We're now 3 times here, Mr. Chairman, and we've made tweaks and addressed these things, and so I definitely think we have a better product. Representative Hardin has done a great job to continue to work to make sure we address those very credible unintendeds and credible concerns, but I think we're at a place where we've done that.
You know, I really like all the free work I'm getting out of Buddy Hardin.
Could I say something? And I don't know the legal ramifications of all this, as I'm sure that the lawyers here do, but the groundwater that would be taken, that the regulated riparian rights say reasonable use of what is under or over your land. Is that correct? The groundwater that the state would use would not be, I mean, everybody else's groundwater, because basically, as I would see it, it would be that groundwater spread out. So this area of it down here possibly is not within the regulated rights of the guy down a little further, or not. See, you see where I'm heading with that? Yeah.
Representative, I don't think we have done anything in this statute that expands the ability to augment water and groundwater. We're doing that now without this bill. We're going to be doing that with or without this bill in the future. What this bill is very clear on is when we're doing that, and the state says, look, this in a very common sense way, if the taxpayer of the state of Georgia is paying to put some water to wet some mussel beds, the taxpayer of the state of Georgia isn't running that system for the benefit of one surface water withdrawee downstream of that. And I hope our friends in the farming community, many would recognize that. But as evidenced by this debate, there's some that wouldn't, and clarifying today before we're in this debate in a drought of how those rights are going to be implicated, and how we're going to deal with this for downstream surface water withdrawers is what this bill is about. This bill doesn't expand, retract, implicate the ability to do an augmentation well in the basin. That's correct in the sense that these provisions are not tied to the drought declaration. But the reason the drought declaration is so important is when we get ready to spend what would have been $20 million on an auction to take people out of take acreage out of irrigation last time when commodity prices had increased 4- and 5-fold. That's why drought for purposes of the Drought Protection Act is so important. What I'm saying is, irrespective of the auction, we have seen, in fact, we saw last year in Spring Creek, we had to augment for about 20 days in a wet year. Now, it was just a period of time where Spring Creek Basin didn't get water. We went from 88 CFS in that creek to 3, and we augmented for 20 days. And we did that in a way that balanced the needs of the basin, that protected those species, that let us continue to grow our crops in the basin. And it was common sense, and that is all this bill's designed to do. Is if we have to do Spring Creek in 5 or 6, 7, 8, 10 other places, and it doesn't need to be tied to some big auction necessarily. It might be in the condition that we get back around to a Drought Protection Act in which we declare the drought, do the auction, and do this. But we shouldn't have to do that. It shouldn't be a $20 million decision by the taxpayers of the state of Georgia to do what we need to do on a very targeted basis to protect some species in the basin so we can continue to work on this problem. If we did not declare a drought and we did this like we were doing in Spring Creek last year, and we restricted flows in that case, and you wouldn't have a payment going on that side of the ledger, but you don't have one now. Sure.
Mr. Chairman, I'm sorry.
No. Aye.